now present For the Record.
Just ahead, a massive issue for Madison City Council members.
It's financially almost impossible.
And a huge step forward for one local undertaking.
The fact that hundreds of black people have spoken and we have listened to what they want.
But first.
So it is imperative that we close this loophole.
Welcome to For the Record. I'm Naomi Coles. On Friday morning, the state Supreme Court ruled unanimously that people with a disorderly conduct conviction related to domestic violence can, in fact, carry concealed weapons. The decision has to do with a distinction between federal and state law. And Justice Murkowski wrote in a concurring opinion that lawmakers needed to close the, quote, dangerous loophole that would allow domestic abusers to carry concealed weapons. A bill doing just that has been introduced in the past in the Wisconsin legislature, but it didn't get a hearing in the last session. I'm joined now by Democratic Representative Lisa Subeck, who co-authored with Republican Senator Dale Coinga. Lisa, thank you so much for joining me today.
Thank you for having me.
So this bill that you co-authored, again, it's a bipartisan bill. Talk me through just the basics of how this would close the gap between state and federal law.
Sure. So under both state and federal law, somebody who has been convicted of felony domestic violence is prohibited from owning a weapon. Under federal law, there is a prohibition specific to misdemeanor domestic violence convictions, but our state law does not mirror that. And unfortunately, because of the way the federal law is written, it does not include all misdemeanor convictions in the state. And this actually came to my attention via prosecutors and law enforcement some time ago, because they were having trouble charging these offenses. Because although it was a violation under federal law, because it wasn't a violation under state law, they were not able to criminally prosecute it. It would have to happen at the federal level, and that just wasn't happening. This loophole only shows all the more why we need to pass our bill and why we should have done it a long time ago. In the opinion today, the loophole that was used is that somebody who is convicted of disorderly conduct in a domestic violence incident would not be qualified the way the federal law is written as being prohibited from owning a firearm. And unfortunately, domestic violence incidents are often pleaded out, and often the end conviction ends up being for disorderly conduct. So it is imperative that we close this loophole and be able to prohibit people who have been convicted of domestic abuse from owning a weapon, no matter whether it was a misdemeanor or a felony conviction.
Now, this never got a hearing. Did you ever get a sense of why not? Were you ever told, like, hey, this is why we're not going to be bringing this up?
We have introduced this bill now, Dale, or Senator Coinga and I have introduced it in the last 2 legislative sessions. But variations on the bill were actually introduced by myself and others for a number of years before that, and at that time without bipartisan support. Certainly, there are a number of gun owners groups who have turned this bill into a boogeyman. We actually had a lot of bipartisan support to begin with, and a number of Republican authors removed their names from the bill under pressure from some of these, NRA and other local gun owner groups. The reality, though, is that if an individual is a victim of domestic violence, they are 5 times more likely to end up a homicide victim if there's a gun present in the home.
Do you have a sense of either how many permit holders currently this decision may affect, or I think more importantly, how many people without a permit who might now qualify to get one? Do you have a sense of how large a scope we're talking here?
Sure. So I don't know the numbers on that. I mean, I think that certainly remains to be seen. The reality is that people can own a gun without a concealed carry permit as well. And so regardless of the fact that this loophole exists in the context of our concealed carry law, it is also a bigger loophole in our laws around gun ownership. These are folks who are dangerous individuals with a history of domestic violence who absolutely, in no uncertain terms, should have access to firearms.
What would you say to, and this is just to paraphrase what the lawyer said in this ruling, who won the ruling, he's like, if we want people to not be able to have a gun if they have a past domestic violence conviction, tell prosecutors to charge them with stiffer charges. What would you say to that?
You know, domestic violence is incredibly complicated, and certainly there are options to charge with stiffer charges. I don't know that in all incidents that's necessarily the answer. Certainly, when somebody is a survivor of domestic violence, it can be difficult to have to get on the stand and testify. It's one of the many reasons that these cases are often pleaded down to lesser charges, is because for a survivor, the additional trauma of testifying can be too much to bear. Oftentimes, these are he said, she said type incidents where there is evidence, but certainly there is worry about being able to get a conviction at a higher charge. Sometimes police are able to intervene before things get to the level of violence that results in a felony conviction. The reality is, it doesn't matter if you abuse somebody a little or if you abused them a whole lot. You having a gun creates a greater danger for that individual. As I said, in an abusive situation, the presence of a firearm makes it 5 times more likely that that will have a lethal ending.
Lisa, I really appreciate your time this morning. Thank you.
Thank you for having me.
Now, as of taping, the Republicans who chair the committees where the bill needed a hearing, they have not responded to questions. When we come back, the state Republican convention is underway. Political reporter Will Keneally gives us a look inside.